can we accept them as read from May 17, 2022? Are there any questions or can we accept as read? Can I get a motion?
Move the minutes be accepted as read.
Second?
Second.
All in favor?
Aye.
One abstention, Chairman.
I also abstain. I wasn't here.
Okay, so the two people that weren't here last month both abstained.
Okay.
All right, and then we'll go back to Rich for bills and claims for July 2022.
You've received bills and claims that total $53,311.48 for tonight's meeting. We had a replenishment by the developer of $45,000. And the current balance after the bill was paid tonight will be $9,962.30.
Thank you, Rich. Do we have to accept that, Mayor?
You need a motion to approve the bill list.
All right, can we get a motion to approve the bills and claims?
So moved.
Second.
All in favor?
Aye.
All right, that takes us to number 7, the chairman's report. I mean, I don't really have any new facts or information until we talk to our lawyer, who will be coming up soon. So I'm pretty much done. We'll go back to Rich. Do we have any correspondence?
We do not.
All right, from correspondence, we'll go to old business. Does anybody have any old business? All right, we're going to go to new business, and that's where we do have some things.
Yes, Mr. Chairman, if you would. The litigation, particularly in the condemnation matter, continues to proceed as well as in the bankruptcy action. In the bankruptcy matter, the 3 corporations controlled by Mr. Berger have filed another bankruptcy claim. It was stated during the affordable housing litigation by Mr. Berger that the claim was filed in an effort to stay the condemnation action, meaning preclude it from moving forward at this time. The borough's bankruptcy counsel has indicated it does not believe that that's the case and has filed a motion actually this afternoon seeking a ruling that the condemnation matter can and should proceed. I hasten to add that because at one of our last meetings I indicated that there would be a status conference scheduled for June 14, that in the district court in the condemnation matter, the trial judge did postpone that matter in light of the claim by Mr. Berger that the matter was stayed. Shortly thereafter, there was a meeting of the creditors in the bankruptcy action. Present were attorneys for Mr. Berger, the EPA, the developer, as well as the trustee for the United States. The borough was represented by the bankruptcy counsel. It was at that time Mr. Berger did indicate that the main purpose of the new bankruptcy filing was intended to prevent what he described as the quick taking of the property by the filing of the declaration of taking and the deposit of monies into court, and that it was his intention to file a motion for a limited stay that would allow the entire condemnation proceedings to go forward, with the exception of the ability of the redevelopment agency to take title to the property through the deposit of monies and the filing of the declaration of taking. Thereafter, there was a strategy session that has taken place among the defendants in the affordable housing case. And for that portion of it, I would suggest that the redevelopment agency go into closed session to discuss the strategies that were discussed and the impact of same and where the case will be going based upon those things. So if that is something that the redevelopment agency would like to entertain, I would suggest you proceed along with the rest of the agenda to allow anyone from the public wishing to be heard the opportunity to be heard before going into closed session.
Okay, thank you. Does anybody wouldn't have to be discussed in closed section.
So what's the timing on the new bankruptcy, you said,
Could you say that again?
what's the timing for the new bankruptcy?
It was two elements to it. And that is one of the reasons why certain payments weren't made to the debtors, including the borough, through the process, that once there's a bankruptcy claim filed, it stops all other proceedings. That's the allegation and contention that was made. And it also, if you're not going to make those payments, you need to, if you make those payments during the filing of the application, it's a violation of the prior bankruptcy matter. They were also looking to consolidate the 3 separate bankruptcy matters into one. So you have a separate bankruptcy for each of the 3 entities. Some are corporations, some are limited liability companies, that each of the 3 own a separate parcel that's involved in Ford Avenue. So they filed a motion to consolidate those 3 bankruptcies into one. This allowed them to do that, and the court granted that, and there's no downside to the redevelopment agency.
Out of curiosity, does the new bankruptcy affect in any way that when this is finally settled, Milltown getting its money?
Part of the conditions of the new bankruptcy is that it implements the effect of the prior settlement agreement that was reached between the parties. So all payments will be made.
So this is bankruptcy number 3. So there's 3 bankruptcies he has.
There were 3 separate bankruptcies that are now consolidated into one. They're captioned with all 3 parties in it. So basically, it was just a maneuver to try to prevent the redevelopment agency from taking title to the property simply by filing the deposit into court and the declaration of taking.
But it also stalls the original bankruptcy agreement, correct? So he's had
It stalled it for a period of 2, maybe 3 months, but it'll be made whole if it hasn't already, in the very near future, with the exception of the ongoing payments that the debtor was supposed to make. There'll be no impact on the prior bankruptcy proceeding.
Any other questions from the board?
Mr. Cahill, if I heard you correctly, he filed a lawsuit because there was quick action. Is that of taking the property from him? Is that?
That's the term that they use. It's not usually referred to that, but it is the ability of a government entity to take title to property through a condemnation matter before there is a full determination as to the value of the property, and that under New Jersey law, which the federal government is following in part in this condemnation matter because it's been transferred to the federal district court, that a government entity can take title by the filing of a document that's called a declaration of taking and the deposit of the government entity's estimated value of the property. And then once that happens, title transfers to the government entity, in this case the redevelopment agency, and the redevelopment agency becomes the owner of the property, and the parties then, for lack of a better phrase, do battle over the value of the property.
It's something that was not unknown to Mr. Berger for the 20-some-odd years that this is going on, that he was aware that this day was coming for quite a few years, not something that just creeped up on him.
It was Mr. Berger who was looking to force the filing of the declaration of taking and deposit of monies in the federal court and filed a motion to that effect. And then didn't like the judge's ruling on the amount of the deposit. So there's some sense that there may be some forum shopping by going to the bankruptcy court to try and get relief from that.
Thank you very much.
You're welcome.
Anybody else? All right, so we'll move on to number 11, which is audience comments. Who would like to go first?
Thanks, John.
Yeah, no problem.
Richard Lewinsky, 14 Elmwood Drive. Two quick questions, just being caught up here. Has the declaration of taking been filed?
Can I answer directly?
Absolutely. Yeah.
Okay. Yes.
Yes, okay.
No, I'm sorry. The answer is no.
Oh, no.
Yes, I can answer direct no. The
Yes,
answer is
For
no.
the record, the answer is no.
No, it is not.
And then, so then I assume the monies have not been deposited yet.
The monies have not been deposited yet.
Have they reached an agreement on the, I guess not, right, that's why he's going back, let's see, to find out if we can get a different appraisal on the value, or different appraisal on the property.
Appraisals have been submitted by both parties, multiple appraisals, both for the round of condemnation commissioners hearing, and now appraisals are being exchanged as it moves forward to the jury trial portion of the litigation.
And when is that jury trial portion?
It hasn't been scheduled.
Thank you.
We've been spending a lot of time in corporate date. Anybody else? I know it's there.
Pete Mangrel, 73 Oaks Avenue, Milltown. As far as the appraisals on the property, has that been made public, what each side is at?
I don't know the answer to that.
Okay, I know that at one point, Mr. Guerrero, some reason 7.65 million was coming up in my mind for an appraisal. I don't know if that's his, or...
Mr. Borai does not have an appraisal in this matter.
Okay.
All right, so the parties in the litigation are the redevelopment agency and the public entities, the business entities that are controlled by Mr. Berger.
Okay. Are we going to be so far apart when we get to that end, as far as the appraisals, that this thing could just collapse? In other words, what I'm saying is, if Mr. Berger, and I've read some of the court documents going back to 2020, the original bankruptcy, and some of the judge's rulings in that, he gave deference to Mr. Berger's 50 years plus of development and everything else as far as his ability to judge the appraisal of a property. And from what I understand, I don't want to throw any figures out that I can't back up, but I understand that there's a disparity somewhere, a large disparity in the appraisal of the properties. And if in fact this appraisal comes out very high in Mr. Berger's favor, how much do we have, or are we still in the game for this? Is our redeveloper going to be able to, and the town going to be able to afford such a number?
These are, this is what happens in every condemnation matter. The attempt of any entity that is looking to take title for a governmental purpose, like in this case, is to always attempt to take the property not by way of condemnation, but through a negotiated settlement. This case has been going on for 20 years, that the parties have been consistently far apart. That remains true today, and no matter what dynamic happens, it seems that the disparity continues to grow. It certainly doesn't get any smaller.
No.
Your question as to whether or not could it unravel or fall apart, the answer is yes. That, and I'll speak on behalf of the redevelopment agency and some issues that come into light. If there is an award from a jury that and that's appealed success and is upheld on appeal, that the value of the property is so much so that the economic development of the site, in accordance with the plan, the redevelopment plan to accomplish the residential and affordable housing development under Mount Laurel, if it is no longer economically feasible, then several things will happen. The developer will not be able to develop the site in a way that meets the standard of the redevelopment agency, and it also increases the likelihood of failure. And I would suggest that the last thing the redevelopment agency wants is a failed project. So those numbers need to be, through the course of, discussions and negotiations, et cetera, or analyzed, et cetera, but it's been a moving target over the last, at least decade that I'm familiar with. As market conditions change, so has the value of the property.
Well, that's exactly my concern, is that we're getting to a point now that property values are going up. This has gone on for over 2 decades. And, the price in 2001 obviously is not the same as 2022. And as we keep going further, where is it going to be? I know Mr. Borey does not have an endless supply of funds. I understand. He does fund this agency. When do we get to a tipping point where it's no longer viable and this developer walks away? And that's a big concern of mine. I mean, there's other factors that I would take into consideration why he should walk away or would walk away. But, I mean, after 20 years of what's going on here, it doesn't seem like we're ever going to get to an end here. And Mr. Berger has proven to be a wily opponent. Okay, he knows the ins and outs. He knows how to do things. I mean, I've researched other projects that he's been involved in, and he's pulled the same thing. Okay, other properties not. One of the things that bothers me is, have we ever sat down with Mr. Berger? I don't know. I mean, I'm new to the game here, and I know a lot of people here have been around for years, maybe not on this committee, but have we ever sat down with Mr. Berger? Because 20-some years ago, when Mr. Borey was given the right to be the redeveloper for the town, all the people that were involved in that at the time are no longer here. They're either dead, moved away, or whatever, because it's been that long.
Not all of them.
Not all of them. There's most of them. Okay? And I'm it's pure speculation, but something happened 20-some years ago to put us on this track with Mr. Berger. I don't know. That's just my belief. That something happened 20-some years ago, that Mr. Berger is dead set. He's going to stay as an opponent to this town until the day he takes his last breath. Okay? It just seems like, I know he's a businessman, but it seems like he's a businessman with an agenda here. And I don't know if we've ever sat down with this man and said,
Well, the answer to your question is yes, on
Okay.
multiple occasions.
okay, good.
And multiple occasions, oftentimes multiple times a year, at least over the 10 years that I've been engaged in this process. And from my understanding, the same was true for the 10 years prior to that.
And what was that? He was non-receptive, or?
Like a lot of negotiations, you give a number and somebody gives you another number, and the numbers are so far apart, and there seems to be no movement on one side, and that wasn't the redevelopment agency side.
I know no one here knows.
There's been settlement conferences held in multiple courts over the years, none of which have produced any progress.
I don't know if anyone knows the answer to this, but I see that Mr. Berger in some of his past projects has offered the town people that he knows as redevelopers to work on properties that he owns. Has that ever been brought up? And I'm not saying we're throwing Mr. Borey out to dry, out the washer, but at the same point, the man who actually owns his property, has he ever been given the consideration of working with the town, with a developer of his choosing?
There was litigation that took place prior to my involvement, I want to say 2010 or 2011, where Mr. Berger indicated he was going to develop the site himself. He has no prior experience in development, particularly in residential. He buys properties and manages them, more or less. There have been conversations that took place during the course of that trial about the likelihood of the property being developed with Mr. Berger involved. And from my understanding, they were not fruitful.
Would they be fruitful today, though? considering all the legal issues that we've come upon, is, do we know if this man is even receptive to sitting down? Because I'm not to interrupt you, but what I'm trying to do is say, I'm looking at a timeline of, you know, it's motions, appeals, they're going in, you've got bankruptcy, another bankruptcy, and it just keeps going on, because he's very good at it. The way, and I'm gonna be honest, the way it looks to me is as if this thing is gonna stretch up until 2030. Okay, I mean, if we were to take possession of the property at some time in the somewhat future, by the time it's cleaned up and built and everything, we're gonna be 5, 6, 7, 8 years out.
I think that's a bad estimate.
I hope it is.
I think you'll see that in all likelihood a jury trial will take place. I don't think it's likely before the end of this year.
Okay.
I do think it would be in the first half of 2023. At that time, there would be a determination by a jury as to the value of the property. There will be assessments made as to the likelihood of success on appeal of those, of that jury trial. There are parameters that are different today than existed perhaps 15, 20 years ago. The developer has millions of dollars invested into this project thus far. The pulling the rug out from them to do business with the current owner of the property likely leads to some further discussion and perhaps another round of litigation. But I think the question you have to ask yourself, and one that the Redevelopment Agency has asked itself continuously, is would you really want to do business with the person who has maintained the property in the condition that it is today and had been for the 10 to 20 years before that and hasn't been responsive to the cleanup of the property, both environmentally as well as the debris, etc., and has continued to put uses on the property that are not in accord with the rules and regulations and codes of the borough. So, you know, those are the types of things, I think they're very legitimate questions, but the answers are not always black and white, and that there is something in between. And thus far, this agency, and I think reasonably so, has continued to stay the course to try to meet its obligation to build affordable housing under the court decision that took place in 2011 or 2012.
No, I agree with what you're saying. It's just, like I said, as a resident, and like now digging into it deeper and deeper, reading some of the past court proceedings and everything else that went around this, it just seems like we're just spinning our wheels again. I hope that's not the case. It just seems like we're spinning our wheels, and another appeal, another filing is going to come down, and it's just going to keep pushing back and pushing back.
It certainly appears that way, and sometimes, candidly, it is. The wheels are being spun. But this case, notwithstanding what the property owner might say about anything, is all about money. And it's the property owner's attempt to, and look, there's technically nothing wrong with that.
No,
You know,
it's
it's a business, and that's what they do, and trying to hang on to the ability to make money for as long as you can and to preserve the property and to derive the income that's generated from the property, and then to escalate the value of the property as much as you possibly can. There are also creditors involved that are looking for, you know, certain judgments to come out, certain values to come out of the bankruptcy court, so that the creditors can be paid in full the amounts that they're due.
Wasn't that decided back in 2020 with the creditors, and everybody pretty much, it was unanimous amongst the creditors to follow Mr. Berger's plan on his repayment for bankruptcy?
There is a payment, they agreed to accept a payment plan. And that payment plan is supposed to take place, if I'm not mistaken, over a 5-year period.
Right.
But they're not at the end of that.
Right.
And so there are monies that are still owing. And unless and until they're paid in full, I would imagine they're looking for their best options to be able to secure payment in full.
But in that same hearing, Mr. Borre was the only one who opposed. He didn't agree to the bankruptcy. He was the only opposing party in that the judge ruled against that, saying that the liquidation of the property would not be beneficial to the other people.
I believe you are correct. I don't
Yeah.
represent the borough or certainly not in the bankruptcy matter, but I've read the documents. I think you are correct, and I think even the borough joined in executing the settlement agreement.
Yes, it did. And it's just, as far as Mr. Berger was, as far as Mr. Borre at the time, the judge said that Mr. Mr. Borre was the only one with, as he said, skin in the game. And that liquidation would benefit him, but it would hurt the creditors, the other creditors.
I don't know that the judge opined that it would hurt the creditors.
Well, they won't be able to collect the money if we liquidate the property.
I'm not sure that's what the judge said.
Okay.
And Peter, you may be right if you read the document more recently than me and have a specific recollection. I think that the judge was persuaded by the creditors not objecting to the plan, and that they at least thought it was a plan that would help them get paid back in full.
Thank you.
Mr. Macaroni? And please, anybody up here, correct me if I'm wrong, because I most likely could be. If I'm correct, Mr. Berger, and it was in litigation that when we came to the plan, he proposed a plan of his own that was 550 units, which was an astronomical number opposed to what Mr. Borre proposed, and I think there was a judge ruling on that. So he was awarded every opportunity to develop that property, but his plan was not conducive to what would be best for Milltown.
Right. No, and I agree, but again, like Mr. Cahill said, Mr. Berger is a businessman, and he's going to try to get, I'm not defending Mr. Berger, I'm not as a party to him, but I understand his point, I understand Milltown's point.
No, I was just addressing that you wanted to know if he was ever given the opportunity to develop the property.
Right.
He absolutely was.
And based on other rulings that have come out in the past 10, 15 years, has that been revisited with him?
It would, and that's a very valid point. When the boroughs, when the New Jersey Supreme Court issued an opinion in the absence of COA being functional, it gave the obligation to determine and responsibility to determine third-round affordable housing obligations to the Superior Court Law Division, the trial division. And it was then that the Law Division was getting a number of appeals to determine the third-round obligation and how to litigate that. So Mr. Berger filed an action that was heard in the trial division in 2000. Well, the case started in or around 2015. It ended in 2018 or so.
Right.
It was decided by Judge Natale. There was a trial that took place over a period, it extended over a period of 2 years, not all intact. There was 1 or 2 weeks of trial, a 6 to 8 month pause, and it leaked into the subsequent year. The judge ruled, and the parties were permitted to submit proposed development plans. The redevelopment agency submitted its plan with the 350 units, pretty much what the planning board had approved prior to that. And Mr. Berger proposed not less than 450 units. It might have actually been higher, but it was at least 450 units. The judge ruled that the plan submission and the ability to develop it did not take into consideration proper planning and engineering practices and lacked some environmental sensitivities, et cetera, and that it was overdeveloping the site. And I'm not sure, but it may not have produced the same number of affordable housing units. But I'm not sure about that. But at best, he had the same number of affordable housing units, but 100 more units on the site that would have changed the density of that site well beyond anything that Milltown has seen before.
Thank you.
Hey, Pete, just to answer your question on has any of us sat in, so the 2 years since I've been mayor, 2 years ago we had a settlement conference that you all zoomed into during the pandemic. Mr. Berger was a party to that. And then just and they brought all parties to speak with the judge. And again, as Mr. Cahill said, they were far apart. The judge, tried to bring everybody together. He even said that, we're getting closer, let's meet again in June. And then, of course, then Mr. Berger goes and files his new bankruptcy.
Thank you.
Good evening, Commissioners. My name is Charlie Prattville. I'm editor of New Brunswick Today, and a New Brunswick resident, and candidate for office in New Brunswick. It's good to be back in Milltown. And it appears this board and this issue are much the same as they were when I last spoke here in 2019. I do have some food for thought to share with the board. But first, I want to ask if I could have a copy of the bill list for tonight's meeting.
It'll be, Kathy, when does the bill list when does things get posted on the website?
Well, the bill list isn't on the website, just the agenda.
Right.
And the minutes will be posted tomorrow.
Yes, in the past, I've just been able to obtain a copy of the bill list on demand here by simply asking for it. Can I get one?
Is there any problem with that?
Zero.
Here, you can have this one. Oh, you got minutes? Okay.
One here, thank you. So I did want to ask about an expense. I noticed someone filed an open request, and it's available on openmachine.com. I see the DEP getting paid $2,000 every month for oversight. I wanted to ask the nature of that payment. Is that the result of any violation, or is that just a contract agreement with the DEP? What's causing that payment?
There was an agreement made with the DEP that led to the $2,000 a month payment. We owed a large lump sum as a result of the original cleanup of the site, where DEP had people come and monitor what was going on. And they came up with a large bill. We did not know at the time they were going to bill us a large amount. And as a result of that large amount, we ended up coming up with a payment plan to pay it back. We owe about $30,000 still to the DEP, so we get about 15 payments.
Rich, if I could.
Sure.
Mr. Cradle, there was a grant application filed by either the borough or the redevelopment agency in or around 2008. This DEP granted, it gave a grant for the environmental cleanup of the property somewhere in the vicinity of $8 million. During the course of that, the environmental engineer retained, did a report and analysis of the property, submitted the report to the DEP. The DEP reviewed it. The DEP charges for its review of the environmental report, and it's involved everything that it does in connection with the environmental report. So the redevelopment agency, as the recipient of the grant, received a bill of $110,000 or so back in the late 2000s. When the borough, when the redevelopment agency received those funds, they negotiated at that time a payment plan. That payment plan has been, there was a first phase that, you paid X amount of dollars, and at the end of so many years, you're going to pay the amount in full. It was renegotiated again, Rich, I believe we are on our last payment. So the last negotiated amount might have been the 30 grand, but that's been paid down now. And I believe there might be one more payment. If I'm off, it's not by much.
I have the bill right here. I haven't even
Johnny
opened it.
Carson.
I can look at it and tell you what they're going to try to bill
But
me.
that's where we're at. You're welcome to the
We
details.
have two checks from here.
Yeah, I see that. Okay, thank you. And so, the other appropriation that I'm interested in is the legal expenses for the agency. I have a copy of your most recent budget. I see the total appropriation appropriations $560,700, and more than 93% of that is legal expenses, which is, a big number. I see 3 different law firms, including Mr. Cahill, on your bill list tonight. I wanted to raise a concern first about the Valence firm. I believe the person you're working with there is Mr. Hoffman, is that correct?
Yeah.
Okay. I will advise the board that I filed an ethics complaint against Mr. Hoffman last week related to his work for the New Brunswick Housing Authority. And, the issue at hand is conflict of interest. Happy to share more details of it, but, suffice to say, he is a board member, in fact, the treasurer of Robert Wood Johnson University Hospital, but still represented the Housing Authority on, applications where Robert Wood Johnson was a core partner. So I do have concerns about him, and in particular with relation to conflict of interest. And, that brings me to Mr. Cahill, who, of course, as you all know, is the mayor of New Brunswick. And I am concerned about the conflict of interest that presents. Certainly, with Redevelopment funding this agency in its entirety, and such a huge portion of the agency's budget going to legal expenses, both to Mr. Cahill and other entities that he has to work with as your legal counsel. I'm concerned that that can present at least the perception of a conflict of interest. And I do want to point out that, as a resident of New Brunswick, I'm not the only one who is concerned about Mr. Cahill and him not being available or accessible in New Brunswick. I'll note he has been paid by my count now some $35,000 just this year alone by this agency, which puts him on pace to be making more at this agency than he is with his city government salary. And I'll note he has not held a press conference since 2011, hasn't attended a city council meeting in New Brunswick since 2012, hasn't given a State of the City address since 2019.
Can I stop you for a second?
Certainly.
What about now just sounds like you're ranting on about Mr. Cahill's ability as mayor, which really doesn't have an effect on this board. I mean, he's hot as legal counsel for this board. His company's been doing this kind of legal work forever. I mean, lawyer costs are lawyer costs. We personally don't like all these courts, all these lawyers that we get. We get paperwork that we get told by the state to give to more lawyers and more engineers that cost more money. The good thing in that whole matter is the fact that the town of Milltown pays none of the bills. It's still being paid by Redevelopment Agency Bori. So in about 2000, I'll go back to 2000, and I'm guessing here in my years, I spent a few years on the Milltown zoning board, and that's when this all started. So Bori's been invested in the project since then. Is he the best developer for the project? I don't know. But he's committed to the town this much money through the years to get to the end of this project. So I'm fine with your questioning Bori. I'm fine with your questioning Mr. Cahill as a mayor. I mean, as a lawyer. Questioning him as a mayor really doesn't play suit here. So I'd like to avoid that.
Fair enough. I'll summarize by saying that conflicts of interest are one of the main reasons people are losing faith in their government, and in particular in redevelopment, and in particular here in Middlesex County. So that's the reason that I wanted to raise these issues. Full disclosure, I'm a candidate for office in New Brunswick. We're opponents, and you're right to point out I should be speaking about business that's of interest to this board.
This is Milltown. That's
Yeah, and I certainly, do hope that you'll take all of this into consideration, because it seems like, the interests of this agency are ostensibly to redevelop the Ford Avenue site, and for better or worse, that's not happening with the team you've got. And it's, costing a lot of money, whether, that money comes from the developer or not. Your mission remains to get the site redeveloped, and I hope that you will, take an interest in these conflicts of interest, because they can muddy the waters and make things hard, make it hard to serve your mission. And so I don't mean to impute any of the board members. I respect the work we're doing here, but I did want to give you that food for thought. And I'm happy to speak with any of you outside of this meeting setting and share my ethics complaint with you. There is serious cause for concern over conflicts of interest, and that was the point I was hoping to make. So thank you. I hope I made it.
No problem. Just so you know, so for 59 years and 4 months, I lived on Clay Street. Exactly, I grew up 3 blocks from this place, threw bricks through the chickadee window when I was a little kid. And now I moved up the street when I got married in '84, and been on the same street. And most of these people here know me. So I came back to the board at the request of someone I know, just to try to get this thing done in a nutshell. And I have never seen so much red tape in my life. And I work for Robert Wood, and we have more red tape. There's more red tape on this board than there is over there. But thank you for your comments.
Thank you.
Anybody else?
Good evening. My name is Patricia. I'm good. My name is Patricia Payne. I live at 2 Korean Drive. I just had a quick question for you, Mr. Cahill.
Patricia
about-
Payne.
Patricia Payne, P-A-Y-N. Thanks. I just was wondering if you could briefly educate me with regard to bankruptcy and why someone would be allowed to file the 3rd bankruptcy.
Okay. Mr. Chairman, if I may?
Yes.
Okay. I'm not a bankruptcy expert. The one thing I do know is avoid it, if you can. But in a bankruptcy, there are multiple levels of bankruptcy. There's Chapter 7s and there's Chapter 11s, and those are the most common that I'm somewhat familiar with. In one case, the case is over, the debtor is throwing up their hands, the assets get liquidated and get split among the creditors. In the other type of bankruptcy, the debtor looks to stay in business, looks to redistribute their funds, maybe negotiate deals, but they're looking to stay in business, sometimes pay creditors in whole, and sometimes not, but they're all on either negotiated agreements or as ordered by the bankruptcy court, using the benefits and the mediation skills of a bankruptcy court. In this case, it's the latter that were filed by the property owners. The underlying theme of both of those is that your debts have to exceed your assets. And apparently in this case, that's what happened a number of years ago. It doesn't seem to have changed based upon hearings that have been held, that I've seen some documents with regard. So that's what happens in a bankruptcy. And when the bankruptcy happens, then the creditors are basically kind of held in abeyance. And the only time that they can get funds from the debtor is if authorized by the court. So all of those types of things are stayed until there's, and by the way, the creditors have the ability to go to the bankruptcy court. The creditors can be the ones that file the bankruptcy claim against the debtor. I don't know what happened in this instance 20-some years ago. But, well, I don't know if it was 20 years ago, but whenever it first started. But in any event, that's the underlying. It's got to be more debt than assets, and either the creditor or the debtor can file it in an effort to try and protect both the creditors, but to allow the debtor the opportunity to at least try to pay.
So as a debtor, so Berger as the debtor, he can continue to reorganize his finances to be able to continually appeal to a court for additional bankruptcies.
No, I wouldn't. The bankruptcy that was just filed was more of a tactical move than it was.
The combination of.
Yeah, it didn't really. It temporarily impacted only because to file the new bankruptcy, you can't be current with your other ones. So it will be brought current. If catch up within the next 30 to 60 days. So that wasn't the reason for the third bankruptcy. So the first bankruptcy will continue to proceed. They're making payments to all of the secured creditors in the amounts that they are required to pay under the terms of a settlement document that was entered into several years ago. I suspect now that you're back on, that they'll catch up with the old ones. They already received permission to make those back payments. But to the first part of your comment, and, you know, he's continually reorganizing, that's an accurate fact, you know, that he's continually looking for sources of revenue from the property that he can utilize to not only help pay creditors, but to in order to his own pocketbook.
Right. You know, because I just based on even tonight's discussion, I keep thinking of what is the benefit, right? What is the benefit to Berger, right? So in a bankruptcy, I can't imagine his legal expenses must be astronomical.
He represents himself in a lot of the things, but not exclusively. So he does have a bankruptcy counsel, newly appointed, in which he has to get permission to have bankruptcy counsel, because that's an expenditure that a debtor has that needs authorization from the court. And he has gotten outside counsel or third-party counsel for the condemnation matter.
Is that, do they work pro bono, or does the
No,
bankruptcy,
no.
does the bankruptcy extinguish the payments to attorneys? Like, how is he managing?
No, he's been able to get approval from the bankruptcy court for that, and understandably so, because, you know, the bankruptcy court will determine the value of the property, thus it will impact the value of his assets. So it is an expenditure that's directly tied to the bank protection of assets, or growth of assets, or diminution of assets, depending on the bankruptcy court rules.
So in other words, to see how it all shakes out in the end.
You know, the key on all of this, and we've talked about, when Mr. Mangarello was talking before, about when is this going to end. I think the light at the end of the tunnel is the jury trial. And, you know, the discovery phase of that is happening now. There will be the setting of a date for trial. Much of that was waylaid because of COVID. There weren't any trials taking place in any of the courts, much less the federal district court. So there was a 2-year hiatus, so to speak. There's a backlog that's been generated. I think a really good estimate is the first half of 2023. Once that determination of the jury is made, it is not a final decision, you know, but it is as close to one as you can get, and certainly further than where we are today. The decision that was rendered by the condemnation commissioners is more of an advisory panel. Both sides can and did file appeals. The jury trial is appealable, but you're going into another level. You're not just going to a jury trial. You now have a higher standard to win an appeal.
Is the jury trial in Superior Court or is it district?
This one is in the federal district court, which is another one of those red tape things that the chairman was talking about. Pretty standard case for New Jersey condemnation. It was filed in Middlesex County Superior Court. But the U.S. government, through a lien on the property by EPA, has the automatic right to remove the case to the federal district court. They did so. So sometime, maybe the latter part of 2019, the matter was transferred to the federal district court. Removed is actually the right word. Removed to the federal district court, which has its own different set of proceedings. There's sometimes state law pertains, or sometimes there's federal courts that pertain, but it is not the type of thing that the federal district court does routinely, whereas the New Jersey Superior Court does.
Is there an advantage to the redevelopment agency for it to be in district court?
No.
Just a crapshoot, so to speak, even at that level.
It's another level of they're not as familiar with it. It is condemnation matters, while very important, and the issue of valuation, of course, matters dearly to, in this case, the redevelopment agency, and of course to the property owner. But they are pretty matter of fact and cut and dry. You exchange appraisals, you have a little bit of discovery, and then you proceed to trial. There's also much more hands-on involvement by the court, through settlement negotiations, et cetera. And while we've had settlement negotiations at the state level in connection with the affordable housing case, they've been fewer and farther between than they would be when the sole issue, as it is here, is what's the property worth. That is the singular issue.
So the heart of the issue, if you had to, say it in a sentence, is that the longer you hold onto the property, it drives up the appraisal, and then that would outweigh all the money that he's spending on lawsuits. Like, I'm trying to figure out what is the benefit?
To him?
Yeah.
Right now, the benefit is he continues to keep the income that's produced by the
And so
property.
what income is produced by that?
The tendencies that he has on the side.
Sandy trucking. The trucking, the vans, any of the factors down the end, he's still collecting the money.
Oh, I didn't know that was.
And then he's renting the property out for parking on, which we all see, which is
So then at some,
Illegally, of course.
so then at some point, if the township assumes ownership, right, then they would also assume ownership of that? And then
Yeah,
those
yes.
are the redevelopment.
So the redevelopment agency would be taking, would be all that, whatever's burgers, gets taken over by us. And we're not going to run a trucking company.
Do you have a headache yet?
Yeah.
I'm new to this, I wanted to learn a little bit. Wow.
Be
But
careful with
thank you
that.
very much. Thank you.
It's much more exciting. Anybody else?
Hello, Randy Root, 88 Clay Street, Milltown. Full disclosure, I am here to talk about historic preservation, how it relates to this property. I am the chairman of the Milltown Historic Preservation Committee, and have been for 2 or 3 years. So one of the issues that I noticed in the most recent four-party agreement from, I believe it's July 8th, 2021, is the delivery of open space and development parcel. It's really just the beginning, where it says demolition of buildings, structures, and any and all structures or buildings, parking lots, sidewalks, walkways, asphalt or concrete pads, and any of these below-grade pavement. It goes on like that. So that's for open space, as well as the redevelopment portion of the parcel. Now, the first thing I think of is the 2 iconic structures that are used throughout Milltown to represent Milltown. That's the water tower, that's the smokestack. And yes, they're blighted, but I don't hear anybody talking about the smokestack being a problem. It's a pile of rubble. So I'm curious how the redevelopment authority might be able to try to preserve these structures, these iconic structures, by modifying or making potentially an amendment to the four-party agreement between only the 2 parties of that four-party agreement. So you leave that four-party agreement, but make maybe an amendment between the county or whoever would own the open space component and have an agreement with them, another 2-party agreement, broken down to preserve landmarks maybe? I don't know. But I'm asking the redevelopment authority what they can do to try to preserve those 2 structures that mean a lot to the community.
I have a question, I don't know, maybe you know, or maybe Rich knows. Is the smokestack and water tower, I've only seen the layout, I've never seen it laid out over the whole map. Do they fall into the development agency part, or do they fall into where the housing to be built, or?
It falls into the residential portion of the property, even under the county's agreement. I think the points are well taken, but the redevelopment agency's responsibility is to negotiate the redevelopment agreement for the property, and then to make sure that the property is built in accordance with the redevelopment plan that has been reviewed and recommended by the planning board and then approved by the governing body. The present plan doesn't call for the retention of those items. So this agency is without authority to plug it back in. So the place to do that would be to revisit the redevelopment plan.
Okay, so my understanding is that there's been a rough plan, a rough conceptual layout with a bunch of typos saying 21 or something on it. So way in the future, 100 years out, that this is going to be built. But in all seriousness, it's really just the back half that's going to be preserved open space and about, and it seems to be vague, 50 to 100 feet buffer zone. It seems to me that the way that the parcel would be ultimately subdivided into the open space and the actual redevelopment parcel could be pretty amorphous. As it's laid out now, it's just a straight line, back half, open space. This thing could be a trapezoid. It could be all sorts. The lines can be drawn in any which way to try to put those elements into the open space component. Because nothing's come yet. Nothing's come to a site plan or anything like that. So I guess my question now is, who determines what those open space lines are and what parties agree to that?
It would be it could happen in a number of different ways. Not in a number of different ways, there's a number of different entities that would be engaged in the process. One would be the governing body, through a review of an updated and more detailed concept plan. And then the place that it really gets down to the nitty-gritty is the planning board, where there's a site plan application that's filed. And then on the open space equation, then the county commissioners would be engaged in that with a sign-off on the final delineation of where the open space would be. And the borough council would be engaged in that and sign off on it as well. So those are the government entity reviews of those things.
Gotcha. So do you know who would have the authority to, I don't know the right legal term, but to designate a landmark or basically help define what these structures are, with whatever term you want, you define that legally, and then say such and such category of structure in an open space situation, and that must be maintained and not demolished or something like that? I'm trying to better understand who would really work to say, in this open space, we want to keep something.
Anybody who's an advocate for that can do that.
Legally?
Well, there's nothing illegal about it, so yes, it would.
But I mean, it would have.
But you can't mandate it because you are without authority to mandate it, but you certainly have the power of advocacy.
So who would have the authority to mandate it?
Those entities that I indicated to you before.
Okay. So pretty much everybody involved needs to have that, advocate for that and try to mandate it one for various
Share
reasons.
your thoughts on the importance of it, and bear in mind, though, that you also, preserving a historic feature is critically important. The borough is under a mandate to build affordable housing. And in order to do that, it needs sufficient space to build it. I don't know how big a space keeping these items would take up, whether it would reduce the number of units and thus the number of affordable housing units. And so you've heard much about rounds of litigation. There are, this is a builder's remedy suit which prompted this, which means it was the affordable housing case was actually filed by the property owner. But there are other not-for-profit entities that are engaged in the litigation that are really looking to see that the borough meets its second-round obligation for development of the site. Anything that impedes that becomes an issue for them.
Makes sense to me.
Okay. So those are the competing interests.
There's no
There are no applications to the zoning board.
Wouldn't be until they take ownership.
The zoning was modified recently. There were 27 bullet points that were brought to the zoning board that were reviewed by the borough planner, and then those recommendations were approved by borough council without further amendments that were brought up at the planning board. So
That's actually a redevelopment plan,
Right.
not a zone amendment. In some respects, they have similar impacts, but it's a redevelopment plan that was just approved last month.
right. So for the authority, any ideas? Do you share like the sympathy that I have? On
I
that?
share the sympathy you have, because, of course, like I just said, I've been here forever, but, the people around us are on the council, so I wouldn't take it to that, to the levels.
Randy, I share your sympathies, but I disagree.
Okay.
Those structures are in such disrepair and dangerous. I don't think there's a way you can save them. It would cost probably millions of dollars that the borough doesn't have an open checkbook to do
Not
that.
asking for the borough.
Well, then the money tree isn't outside, that they're just gonna come and hand it to you to fix these things. These things are gonna cost way too much money to fix up, to get them in a safe condition that the plan should even be altered. I sympathize with you, I really honestly do.
Are you aware of grant funding that's available for some project like that?
Well, as I brought up to other entities, most grant funding that a county would be eligible for. It's actually kind of interesting, because if that was a county-owned structure, I've actually asked the question, what about the structures that are historic that, say, the Lawrenceburg Watershed Partnership owns on open space land up Washington Avenue? And I haven't really gotten a great answer about that, about the management of that building. That building would be under the same jurisdiction as a smokestack, basically on county property. I'm sure there could be funding, but as I've shared with other people and members of council, the strongest ordinances come, and through legal authority, come from a historic preservation commission. That authority is greater than that of the state in terms of the requirements and obligations. So I'm not 100% sure if there would, I can guarantee there's not millions of dollars for grant money for this. There's certainly money that would be available to ascertain what it might cost to fix it. That I know does exist. How that can be obtained may require many steps or a few steps, depending on each route is a little bit different.
I just think that what you're proposing is admirable. There's so many straps on that smokestack that it would be impossible, I think, to save that structure, to be honest with you. And it would delay this project probably even more years. And I'm going to be honest with you, I'm a resident here in Milltown, that I would be opposed to what you're saying, because I want it done safe, I want it done right, and I want this whole fiasco to end as soon as possible. Now, if that means that those structures can't be saved, then that's the cost of doing business to get this thing settled. And I think there's a lot of Milltown residents that agree with me.
All I'm saying is that there's a whole lot of open space in the back that's going to be whatever, and if you put a 200-foot buffer around that stuff and said, hey, let's at least take the time to figure it out, and you can build the buildings, meet your affordable housing obligations by moving the plot line or lot line 100 feet in the back, why not? That's really where my thought is, and just trying to figure out what I can do.
When we get to the site plan, we can definitely discuss that. I mean, I agree. It's iconic in Milltown. I mean, the property owner owns it now and has let it degrade over the last 20 years. And so when we do, God willing, take title of the land, then, that's something where we can, would it be the county? Would it be the development part? I mean, that's something that,
The problem is that as of right now, by right, they come down. That's the problem. So I'm trying to, we got maybe, a year and a half, 2 years, I don't know, before this might come to the planning board. And I'm saying if things got moved real fast, they're coming down as fast
They
as possible.
can't do anything without coming to do a final site plan.
But there's certain things that they can do by right. They're not obligated to do anything with that unless it's in their mind at the very least now that, hey, maybe we need to carve out a little circle around this. That's the point that I'm really trying to get across, that if any of you are in the positions to communicate that, it may be the only way to buy some time, because what's the worst that happens? They come down, but you got a circular park where at least it used to be, right, instead of it being the corner of a residential building. So, where there's no memory, no marker, just maybe an old picture sitting out, in somebody's window. So, that's all I have.
Okay. Thank you, Randy.
I have a question.
Hello, my name is Debbie Miller, and I'm 92 Ford Avenue. I want to thank you for trying to answer our questions, though it seems like it's been a very long time. And if Mr. Bori is impatient, financially can't keep funding, is there, does he get back pay for everything that is paid?
No.
So whatever's paid out, he would just.
Under the terms of the redevelopment agreement, he is responsible for all costs associated with the project. That would include any of the items that he's paid thus far.
Even if there's a failure?
Even if there's,
A failure?
that's correct. It is his option to discontinue. I shouldn't say, it's not necessarily his option. He has the right to decide not to proceed because of economic infeasibility.
Thank you.
You're welcome.
It's been brought up in multiple senses for various questions.
Name and address, please.
Oh, indeed. David Rand, address 35 Avenue. It's been brought up multiple times that this is an extraordinarily expensive endeavor already on the developer's behalf. I'm wondering if he's illuminated to anybody why he's chosen to continue fighting for this development in legal warfare for 20 years now.
No one knows that answer. I mean, that would be, only Mr. Berger knows why he continues to fight the project. We have no idea why.
That's what's curious to me, though. I can understand why Mr. Berg is continuing to fight from his standpoint. He owns the land. You're trying to eminent domain is his. He owns it. I'm more curious as to the, I'm sorry, Borai? Is that it? Borai. Apologies. Why he has continued to fight for the development from his angle. This is a massive expense, but as has been stated, it's held entirely by Mr. Borai. I'm wondering if he has said why he's chosen to continue the development.
So Mr. Borai so years ago when the Ford Avenue redevelopment first started, I wasn't a part of it, and correct me if I'm wrong, anybody that's been around on this committee longer than me. You go out as a redevelopment agency for a project manager, and someone has to be a partner in there, and Mr. Borai was the chosen participant, and he's opted to stay in the fight this whole along, and I guess in the end, he wants to see the project completed himself, but that would be only a question that Mr. Borai could answer, or his company.
But that's a matter of curiosity to me, because as has been stated, the cost on him has increased. The budget for this county has gone up 300% in this past year, yes?
Right, but you're still answering a question that we really can't answer.
He's a businessman, so he's taking into account what he's paying in and what he thinks he can get out.
I mean, his office is in Brunswick, he's got plenty of guys, I'm sure he's all.
We don't know, we just,
It is very much the case that his office is in New Brunswick. And it is also the case that 90% of this increased budget is going entirely to legal fees, yes?
Once again, I mean, if you're here on a political agenda, we're just here trying to help the town.
I mean, on a business agenda, as a matter of fact, it seems to be an extraordinarily strange thing from a developer whose main point is profit to continue throwing away increasing amounts of money on a legal battle that has no end in sight.
But that's only a question that Mr. Borak can answer.
Indeed it is.
this. Anybody else? All right. So that will end the public comment section. We are going to adjourn and go into private session for some legal counsel from our legal counsel. So can I get a motion to adjourn?
There's a resolution.
I'm sorry.
Did you want to do member comments?
Yes, I'm sorry, I missed it.
Okay. And then there's a resolution, Mr. Chairman, to go into authorizing, going into closed session.
All right. So we got any member comments?
I do. I have one. Last night at the council meeting, we mentioned Ford Avenue and the condition it's in. And anytime that it's brought up, it's been going on for so long that people don't, especially people that are new to town, have no idea of what's transpired. And when I first became mayor, I asked Mr. Cahill to put together the legal history, because we often sit up here and say it's in litigation, and people, they think, how in the world could that be for 20 years, right? So it's not the same litigation, it's one after another, but I haven't seen a clear history of how we got here either, So when any time anything comes up, people will say, and when we were campaigning and people ask about Ford Avenue, they'll say, why doesn't it become a park? Or, well, we'd love it to be an ice skating rink, or we would love it to be this. And if they're new here, they don't understand that we've been involved with this redevelopment plan since the early 2000s, right? So we're still battling through. So what I said was, it might be good to take a history of, and to what Pete said, how did it start way back when? How did we, what happened? Certainly a lot of it is legal, but there are other things that, the borough did, that the developer did, that the property owner did, and let people have a full understanding that, where we are here in 2022 is a result of that. And while we would love to, reinvent the wheel and say, hey, sure, we'd like it to be that too, but we're hamstrung with a lot of this, and we have to do that. So I'm going to request that, going into the fall, we put something together, and maybe we can do like a town hall, because it's 21, 22 years, or maybe new homeowners that are moving into town that were barely born when this all started. And I think it would help put everyone on a level playing field so that we all know what we're talking about. Some of us, I myself don't really recall. I guess I was, newly back in town and had really little kids, and I didn't pay much attention when this first started in the early 2000s. So we'll try and get something together and keep the public informed and have people come and, there's some things we can answer because, it's a history, other things we can't because it's a legal thing, but, try just to open up and say, here's how we got here. We're not happy about it, but, this is where we are, and this is how all of this has transpired. Thank you.
I think that would be great because it would answer a lot of people's questions.
Yeah, they can't keep up with it. I'd love for it to be it should be a dock in a restaurant. Okay, great.
Go put it on Google.
Right.
That's all.
In a good event, yes.
Anybody else?
Okay, we need a motion to go into private session.
Right, I'll read the resolution, you'll take a motion, and if it passes, you'll go into closed session. Whereas the Milltown Ford Avenue Redevelopment Agency has a need to discuss matters involving Milltown Ford Avenue Redevelopment Agency versus SB Building Associates et al., case number 19 CV 21494-ZNQ-DEA, and whereas the Open Public Meetings Act provides that a public body may exclude the public from portions of a meeting and discuss certain matters in closed session, including any pending or anticipated litigation where the public body is or may become a party involving matters falling within the attorney-client privilege. Now therefore be resolved by the Milltown Ford Avenue Redevelopment Agency that the agency enter closed session to discuss the above-mentioned matter. Be it further resolved that the discussion held in closed session will be disclosed to the public upon return to open session.
Make a motion that we enter into closed session?
Second?
All in favor?
Aye.
So you have to go outside, but if you want to go back when it's over, we will explain what it's all about.
Made as to what was discussed during that time. I had briefed the agency as to the discussions that had taken place among the parties to the litigation, both bankruptcy and condemnation, which included the borough, the redeveloper, and the redevelopment agency, that certain strategies were discussed as to actions to be taken in both of those matters. I looked for direction from the redevelopment agency on those matters, and will follow through on those items.
Thank you.
You are now at the motion for adjournment.
Can I get a motion to adjourn?
Second.